Well, it is 1 o'clock. I want to thank you, everybody, for joining us for Savannah Jewish Family Services Food for Thought program. Please note, if you have any questions during the program, please write them in the chat, and we'll have Q&As at the end. Today, I'm honored to introduce Leigh Rich, who is a professor of health administration at Georgia Southern University, where she teaches courses in bioethics, health law, policy, and social theory. She has worked as a journalist, radio host, and editor, including 6 years as an editor-in-chief of the Journal of Bioethical Inquiry. She's an award-winning writer of editorials, news, feature stories, and reviews, and she's currently working as a socio-legal book titled Bodies and Body Boundaries in the Age of Biotechnology. Thank you, Leigh, for joining us today. Oh, Leigh, you're muted.
All right, sorry, you think I'd figured out Zoom after doing this for so long. I really want to thank you, Sunny, for putting this all together, and Adam, Savannah Jewish Federation, the JEA and Jewish Family Services for having me here today, and for all of you joining me. And Sunny, when we were talking about what topic to start off with, you had asked me to maybe kind of do a broad overview of legal cases and other aspects of the law that relate to our body. And so this is a huge topic. It's one I've been working on for quite some time. It's an ongoing project. We might not be able to do a deep dive on so many things. I'm going to try not to do too many detours, and I'm going to keep watch of the time. But primarily what I want to do is look at cases or other issues that have shaped the rights that we have in our bodies and our decision-making authority in relation to our bodies, primarily, but not solely within a medical context. One of the things I always have to mention, I am neither a clinical health professional, nor am I a lawyer. So anything said here is not legal or medical advice. I'm really a cultural and medical anthropologist. And so I tend to look at these issues from a cultural, historical, and philosophical perspective. And in particular, in my talk today, we're going to focus primarily on civil cases at the state level, but I might touch a little bit on some criminal aspects and also some federal cases. All these different jurisdictions, though, I'll try to clarify so we don't get too confused. Informed consent in particular, and of course, healthcare and medical policies, primarily a state issue. All right. Okay. So I've been, I guess, academically obsessed with the body since about the mid-1990s. And primarily the question that I've been looking at is, when do our bodies belong to us? And how do we know what is us versus not us? And is this always so clear-cut? For me, I'm particularly interested in how biotechnology puts pressure on these boundaries and changes how we know what's us versus not us. Now, I want another little caveat here. It's really hard within our language not to use objectifying Cartesian dualisms. So sometimes I'll talk about rights over the body or rights in the body, but I really approach the body from an anthropological perspective of embodiment, right? We don't just have control over our bodies, we are our bodies, right? Within a lived experience and within certain contexts, but my language is probably going to get a little objectifying. So today, let's focus on, within law and medicine, when do we have decision-making authority in relation to our bodies and why? I always like to start lectures or sometimes even classes in current day. What's happening in the news right now in relation to this topic, to see, why should we care about these issues? And then we'll go back into history and then we'll circle back around. I'm going to try to tie everything together. Things might be a little disparate, but stick with me, go with me. And if you have questions, we can do some clarifications during the question and answer period. All right, so 3 examples from recent news. The first example is happening, the court actually just shut down this lawsuit last Saturday, I believe. We're in a pandemic. right? Questions about lockdowns, masks, and of course now vaccination. In Houston, the Houston Methodist Healthcare Organization, which is a huge healthcare organization, has required that all 26,000 of its employees be vaccinated against the novel coronavirus. And a little under 200 employees have refused to do this. They were given several warnings that they would be placed on unpaid suspension. And if they wouldn't get completely vaccinated by June 21st, they would be fired. And several of these workers filed a lawsuit led by one nurse. And the nurse claims that the vaccine is experimental and dangerous, and that's one of the reasons why she's refusing. This past week, a U.S. district court basically dismissed the lawsuit and says, look, federal law doesn't prevent employers from issuing such a mandate. And the judge in particular called Nurse Bridges' claim that the vaccine is experimental and dangerous false, and just also irrelevant in relation to the law. All right, second example. You probably heard about the identification of the so-called Golden State Killer in 2018, Joseph DeAngelo. Just recently, sometime in the last week or two, an even older double homicide was solved from 1956. Kenneth Gould, who is no longer around, he's deceased, but was identified as the perpetrator in this double homicide. And so we've seen this rise of genetic genealogy, or in cold cases like this, it would be called forensic genealogy. And here's how it works, right? You take biological material from crime scenes, you compare that DNA to samples from DNA databases, primarily GED Match, which is a public database. You locate the relatives of your sample, then you build a family tree using public documents, births, marriage certificates, things like that. You identify potential suspects, you engage in traditional investigation to finally hone in on your perpetrator. There's a public interest, right? There's a public interest in solving these cold cases, right? So I'm not necessarily critiquing that. But if we move over into, say, adoptions or gamete donation, and I put donation in quotation marks because oftentimes when it comes to sperm and eggs, people are selling these, not necessarily donating them, but there's some donation. Because of genetic genealogy and all of these DNA databases and commercial DNA products, pretty much donor anonymity is dead, right? There's really no more closed adoptions or closed gamete donation. And I have a couple quotes here from some articles, right? Even if no one in an adoptee's immediate biological family has entered their profile into one of these DNA databases, the size of these databases is so large that you can at least count on matching with a fifth cousin, and that's often enough to find the person you're really looking for. And one sperm bank, I believe, said there was a woman who had identified her donor, and she was sort of harassing the donor, and this clinic ordered her to cease and desist to contact this donor that she identified using 23andMe. And so really, in our current situation, there's really no such thing as anonymity anymore. And some of us, I think, are a little queasy about that. Now, there are, public interests in solving cold cases. Maybe there's a public interest. We need to have discussions about, should adoptions be closed? Should gamete donation be closed? Should they be open? These conversations have been going on in the law for a very, very long time. Here's where I get most concerned, and I think other bioethicists get concerned. We should be deciding these questions, not technology. And right now, technology is deciding the question for us. Oftentimes, technology is going to move faster than the law. But I really don't know if we want to hand over all of the decision-making to technology and biotechnology. All right, third example, and this is where I'm going to focus today, primarily on the issue of consent. Relatively recently, it was at a conference, I believe, a 2017 Pennsylvania Supreme Court case resurfaced. This was a narrow decision, a 4-3 decision in Pennsylvania. Per this court case, right? A physician or a surgeon must now engage in the consent process with a patient and not delegate it to his or her subordinates, right? That the physician or surgeon, him or herself, has the obligation to engage in that informed consent conversation. This has made a lot of healthcare professionals and also medical researchers in Pennsylvania pretty nervous. Because they don't have a lot of time, and oftentimes you do delegate, and you also want to train your underlings to become superiors at one point in time. So people are pretty nervous. Now, if we go to the other side of the country, a Court of Appeals of California a couple of years later does reference the Chanel case from 2017, but they agree with Pennsylvania's dissenting opinion. They say, look, a physician or surgeon can delegate the consent process, although he or she might still be held liable if it's not done appropriately. And they emphasize that the Chanel precedent in Pennsylvania basically injects the judiciary into day-to-day medical matters or medical practice. We don't necessarily want that too much either. But what I find curious about the Jaffe opinion out of California is it, in 9 pages, it's a fairly short opinion, it mentions the consent form 21 times. Things like the patient never claimed that he did not actually read the consent form. The patient signed the consent form. Here's one of the quotes from the judicial opinion that I find pretty problematic, right? That the doctor also argued that the fact that the patient signed the consent form shows that the patient did give informed consent. And I will circle back around to this, what exactly is informed consent? Is it just because the patient signed the consent form, or is it something more than that? All right, so what do all these things have in common, right? They all focus on the body in some sort of way, and they also focus on issues of consent and privacy and decision-making authority that we have in relation to our bodies and in relation to our tissues, even when those tissues are separated from our bodies. All right, let's focus on consent first. And like I said, for the most part, that's where I'm going to stay. The idea of consent within the medical encounter is not new. And philosophers and other medical historians have been sort of fighting about this. Some say, look, consent is a very, very old concept. We can go back to ancient examples. It's been around forever. Other scholars say, no, you've missed the point. Consent is actually really a modern concept emerging in the 20th century. For the scholars who are on the ancient side, these are some of the examples that they give, right? Hippocrates said that you must coordinate with your patients in order to treat their diseases. Plato said, patients know themselves and what is good for them. And therefore it is the physician's role to, through kind of a Socratic type of dialogue, encourage the hidden knowledge that the patients have about themselves and their bodies and their illnesses to emerge, right? Using these proper arguments. And a couple of other examples come from Alexander the Great or Justin II. The story goes, Alexander the Great was wounded in battle, and he was in need of a surgeon to help him. And what he did is he declared his wound incurable. And why, right? Well, because A, he needs medical treatment. His surgeons or physicians on the battlefield are going to be hesitant to do this because, well, if he dies, they might be held liable for this. And so Alexander the Great, according to these scholars, declared his battle wound incurable in order to say, look, if you treat me, because he wants treatment, if you treat me and it's successful, great. If you treat me and it's not successful, it's my disease, it's my battle wound that killed me, not you. Same thing with Justin II. The story goes, he handed his surgeon a scalpel to undergo a procedure to emphasize that it was his choice to undergo that procedure, that he was not being coerced into it by a medical professional. We can come over to a little bit more current times. New York's founding laws required physicians and surgeons to obtain consent, particularly if an intervention was risky. One of my favorite historians, Mary Fizell, has a paper about England in the 18th century, where she talks about during this time period, there was a crowded medical marketplace. You had so many different practitioners in the medical market that when patients came to you for treatment, the patient's narrative about what caused their illness and how best to treat it was placed on almost equal hermeneutic footing with that of the doctor. It was more of a negotiation. And of course, why? Well, if a patient didn't like what a doctor had to say about the cause or the treatment of their illness, they could probably just go down the block and find another practitioner that would, maybe go along with their perspective. So I sometimes ask my students about this, look, are these true examples of consent? Or is this, look, you have to have a patient who cooperates with you. So you probably should talk to them and get their agreement. Or is it about limiting liability of the physician or the surgeon? Or is it about free market competition? If we come to colonial times in the United States, right, we take a look at our founding documents. And yeah, I tell my students, maybe it's like with children, like you shouldn't ever, have a favorite child or whatever. I don't know if you should play favorites with the Bill of Rights or our amendments or any part of our founding documents, but I sort of do, right? We all love the 5 freedoms in the First Amendment. We definitely don't, we want to safeguard those. But really, one of my favorite amendments is the Fourth Amendment, right? Because here is one of the very few places in our founding documents where we specifically talk about how someone should be able to be secure in their person, right? Secure in their person's houses, papers, and effects. Now, the Fourth Amendment has roots that go back quite a long ways. The right to be secure against unreasonable searches and seizures. There's a lot of, it's a complex amendment. The history is very complex. We could spend, probably 4 days just talking about the Fourth Amendment. But one of the other reasons why I want to mention the Fourth Amendment here is because one of the reasons why people in colonial times wanted to be secure in their persons, houses, papers, and effects against these unreasonable searches and seizures, because some of those unreasonable searches and seizures were breaking into people's homes to determine whether there was a smallpox infection there. So we have a little bit of a disease element tied to our Fourth Amendment. And we also have a little bit of a disease element tied to our Third Amendment as well. We don't talk about the Third Amendment all that much, right? We talk a lot about the Second and the First, but the Third Amendment, oddly enough, is applicable even during our pandemic today, right? One of the many reasons why people didn't want soldiers and others to be quartered in their houses is because sometimes those soldiers would come with disease, would come with smallpox and would spread disease. So there's a little bit of a medical or disease aspect even embedded in the Third Amendment. That's one of my little side alleys. Let's come back to the modern era, right? The rise of the idea of consent in the 20th century, particularly the early 20th century. One of my favorite cases, Union Pacific Railway Company versus Botsford, is a case that in 1891 goes all the way up to the US Supreme Court. It starts as a negligence suit. You have a plaintiff, Clara Botsford, who is a passenger on the railway, and she gets injured, right? When a berth falls on her head. When I talk with this about my students, they have no idea what I mean by a berth, and I tell them they need to watch more old movies. But it was an upper sleeping berth, the negligence of the railway for not maintaining their facilities. It falls on her head. In the court case, she says it causes permanent and increasing injuries, both to her brain, her spinal cord, and a concussion. So of course she sues. She sues the railway company. Now, 3 days before they go to trial, the railroad moves for a court order to compel what the case calls a surgical exam to determine the extent of her injuries. That's the language they use, but really what they mean is a medical exam, not necessarily for her to undergo a knife, but to be, examined by one of their doctors to see, how injured are you really? And the Circuit Court for the District of Indiana denied the motion. So this case goes all the way up to the US Supreme Court. Can you compel a plaintiff in a negligence suit to undergo basically a medical exam? We get some really great language from this judicial opinion from this case, right? The majority opinion says no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his or her own person, free from the restraint or interference of others, unless by clear or unquestionable authority of law. I raised the Fourth Amendment as well, because even though the Fourth Amendment primarily protects us against government intrusion in relation to criminal matters, and here we're talking about a civil tort case, I really think that the language is very, very similar. And then the majority opinion goes on to say, quoting Judge Cooley on torts, the right to one's person may be said to be a right of complete immunity, the right to be let alone. So Botsford wins. She doesn't have to undergo any kind of exam by the defense. Now, this doesn't stick around forever, right? If you've ever been involved in or know about a negligence suit, right? Prior to this, in the 1860s or so, there was a court case out of New York that said, look, someone who's injured by someone else's negligence can show his injuries in court, as long as you do it in a discretionary manner. So why can't the defendant ask for any kind of examination to see, okay, how bad are your injuries really? By the time we get to the 1930s, and there are changes in federal procedure, civil procedure, we start to see the rise of, yes, a defendant, actually any movement in a court case can require through the court what we would call a physical exam, right? It's not surgical. Most plaintiffs' attorneys don't want it called medical. You are not testifying while you're undergoing this exam, and they try to retain very tight control over what actually happens during these exams. But I love the Botsford case because we have this great language about our right to be let alone and our right to control our person free from that restraint unless by clear and unquestionable authority of law. Some of the other sort of foundational cases in relation to consent from this early 20th century period. One is Moore v. Williams out of the Supreme Court of Minnesota. Here's a case where a woman was complaining of trouble in her right ear. She goes and she seeks out Dr. Williams, who is a specialist in issues of the ear, right? Has a very extensive practice. He examines her right ear. He can't examine her left ear because it's being occluded by some foreign substance, so the court tells us. And he says, look, you need an operation. I think there's a polyp in your right ear, and the ossicles, the bones of your middle ear are diseased, and so you need an operation. Moore goes and she consents with her family physician. She has 2 more consultations with Dr. Williams as well. And she finally says, okay, I consent to this surgery. She's in the operating room. She's under anesthesia. Williams can finally examine the left ear and says, look, this is in worse shape than the right ear. He consults with Dr. Davis, who per the patient's request was actually in attendance. Dr. Davis agreed. And so Dr. Williams operated on the left ear, even though Moore had only provided consent for the right. Moore sues over this. She claims that she's having hearing loss and injuries. This case goes to the Supreme Court of Minnesota, and the court here says it doesn't matter that Dr. Williams performed the procedure skillfully and successfully, or that her left ear was more diseased than her right and was in need of that treatment. The court basically said the doctor committed assault and battery. If a physician advises his patient to submit to a particular operation, and then the patient weighs the dangers and risks incident to its performance, thereby entering into a contract for the physician to operate to the extent of the consent given, but no further. Right around the same time, over in Illinois, we have not a completely similar case, but a case also in relation to consent. Maybe even a little bit more of a problematic case for several reasons. Pratt v. Davis. This involved Mrs. Davis, who was a married woman, mother of 4. She had been suffering increasing epileptic seizures for about a decade. They were getting worse. Her husband takes her to see Dr. Pratt. And she is, for a certain part of time of this court case, she is admitted to what we'd call a mental asylum, right? But the court, the Illinois Supreme Court, notes that Davis's mind, except during and following the epileptic attacks, was normal. So Dr. Pratt eventually suggests and performs 2 operations, but he didn't explain the extent of either of the operations he performed. He really obtained very minimal consent for the first operation, and he didn't get really any consent either from Mrs. Davis herself or even her husband for the second operation, in which he removed her ovaries and her uterus, basically a hysterectomy. Now so Mrs. Pratt through her husband sues, Mrs. Davis through her husband sues Dr. Pratt. And Dr. Pratt testified during this court case that he told Mrs. Davis just enough about her condition and worked her deliberately and systematically, taking chances which she did not realize the full aspect of, deliberately and calmly deceiving the woman. That is, I did not tell her the whole truth. That is Dr. Pratt's own language. His lawyer, Pratt said, look, there was no damages that occurred to Mrs. Davis. That was according to Dr. Pratt. His lawyer basically said, look, the employment of the physician or the surgeon gives him implied license to do whatever in the exercise of his judgment may be necessary. And Dr. Pratt wanted to claim that, well, Mrs. Davis was insane, and the surgery was a treatment for her condition, which of course she received no alleviation from her epilepsy by undergoing any of the surgeries that Pratt provided. Mrs. Davis wins at court. The court says, look, what Dr. Pratt did was trespass to the person in a non-emergency situation. In other words, if Mrs. Davis's life was at stake while he was doing these surgeries and had to do some kind of procedure to save her life, that might be a different story. This was a non-emergency, and he clearly trespassed her person. If we go to New York about a decade later, the case of Mrs. Schlowendorf, this is a case that is sort of the case that always gets mentioned anytime you go to any lecture about informed consent. And it's a pretty interesting case, although some people don't mention the aftermath of this case. So who is Mrs. Schlowendorf? Some of the details come from a lot of work done by Paul Lombardo, who really focuses on particularly cases related to women and consent during this time period of American history. We get a little bit of information from the judicial opinion itself, but also details from articles like in the New York World. Originally, her name, she eventually gets married. That's why she becomes Mary Schlowendorf. Originally, she was Mary Berry Gamble. She had lived in San Francisco. She was an elocution teacher. And prior to the San Francisco earthquake, she said her physical condition was pretty much perfect. Now, she survives the San Francisco earthquake, where she was greatly frightened and nervous, and she decides to move to New York. One of her son, who's an adult at this stage, is living in New York, though she didn't necessarily live with him. But she moves to New York, I believe, because that's where her son was. The court case that eventually arises says that she, and the doctor involved, says that she suffered from nervous shock. And I only put this here because it was a way for the defendants to say we can't trust her testimony. So linking that nervous shock, I guess, back to the earthquake in San Francisco. But really what the case was about was she sought medical advice for dyspepsia or indigestion, what the court would later call some disorder of the stomach. And she had tried all these other remedies, and they just didn't alleviate any of her pain. So she enters New York Hospital, the Society of New York Hospital, which is a charity hospital, although she is a paying patient. She's paying $7 a week, I believe, to be a patient there. She sees the house physician, Dr. Bartlett, who finds a lump in her side. And I have lumps in parentheses here because on another examination, particularly by the surgeon, they find a lump somewhere else. So it's sort of like these, what Paul Lombardo calls these phantom tumors, right? They're sort of moving around. But this lump or lumps had been evident for about 5 years. And Mrs. Schlowendorf knew about these lumps. Actually, I think she knew exactly what these lumps were. But Dr. Bartlett brings in a surgeon for a consult, Dr. Stimson. And Dr. Stimson, during the court case, basically describes Schlowendorf as too nervous, too rigid, too tense. And so what he does is he recommends an examination under ether in order to locate what this mass is that's causing her issues. Schlowendorf herself is really cautious about the nature of the exam. She consented to the examination under ether, but only on condition that there would actually be no operation, right? Meaning that if they found something, she didn't want anything to be removed. They could explore, but they couldn't remove. She explicitly told Dr. Bartlett, an anesthesiologist, a night nurse, that she was not to be operated on. And even in her own words, she asked Dr. Bartlett, what do you mean by an ether examination? And he said, well, you give the patient a little ether to quiet the nerves and relax the body, that it really didn't amount to anything. But I told him I don't want any operation. So she's pretty clear. All right, so she is put under ether, taken into the OR, and during the exam, the surgeon discovers a quote unquote tumor. And in consultation with the house physician, what do you think they do? They decide to remove it against her wishes. She wakes up from the operation. She finds a large scar. She's in pain. She's cut across the stomach from hip to hip. Over the next year, she's going to have multiple stays at multiple hospitals to treat various consequences, primarily of this surgery, including one. She said she suffered pains in her arm and her hand, coldness and numbness, developed gangrene in this left arm, and had to have some of her fingers amputated. Now, what was this tumor that the surgeon discovered? They were fibroids. So during the lawsuit, the surgeon eventually testifies that to remove the tumor, he had to cut across the abdomen and tie off arteries, all to prepare for really the main part of the operation that happens to Schlowendorf while she's under ether, and that is a hysterectomy. In her lawsuit later, an expert witness for her said, look, an embolism possibly formed as a result of the surgery, which may have led to the issues with her left arm and her fingers. So this case ends up going to the Court of Appeals in New York, which is New York's highest court. They don't call it the Supreme Court, that's trial level. Court of Appeals in New York. And we get a very beautifully written opinion by Benjamin Cardozo. And of course, we know Cardozo because he's eventually going to become a US Supreme Court justice. At this point in time, he's relatively new to the New York Court of Appeals, and he's relatively green. But he gives us this beautiful language. He was such a great writer, this beautiful language. He says, because Schlowendorff sues, of course, in the case at hand, the wrong complained of is not merely negligence, it's trespass. And that every human being of adult years and sound mind has a right to determine what shall be done with his body, and a surgeon who performs an operation without his patient's consent commits an assault. Just beautiful language that really sort of solidifies the fact that we do have possession and control over our bodies, and we get to determine what shall be done with it, with some exceptions. Now, this quote that I have here at the bottom is the quote that you will probably see in any lecture, any paper written about consent, because it's beautiful language. But here's what you don't often hear, and Paul Lombardo often likes to really emphasize this because you don't get this side of the case. Mary Schlowendorff lost her case. So we do get great language in the opinion, but she lost her case for legal reasons. At the time, charity hospitals were immune. Any wrong might have been the doctor's fault, the surgeon's fault, but not the hospital's. The surgeon was a visiting surgeon, right? The nurses were employed by the hospital, who are part of the case, but they were under the surgeon's control at the time. What happens in this case becomes known as the Schlowendorff rule, that basically exempted certain hospitals and certain healthcare providers from liability. Court in New York in 1924 calls this rule logically weak. And then by 1957, New York basically overturns the Schlowendorff rule. These days, as I like to emphasize with my students, even if a practitioner is an independent consultant, for the most part, hospitals are liable. Hospitals are liable today for what happens within their walls. All right, that's the early 20th century, where we were talking about just consent in general. But what about informed consent? We really start to see this idea or this concept of informed consent come about mid-20th century. And the first legal case to introduce informed consent is a California appellate court from 1957, the case of Martin Salgo, who was having issues with his legs for quite some time. And his doctors suggested that, look, we need a diagnostic procedure. They have him undergo this translumbar aortography, which through this procedure, they find out that his aorta in his abdomen is blocked. But the next morning after this diagnostic procedure, he wakes up and he has paralysis in his legs, which at least according to the court case was permanent. So Mr. Salgo, his wife and his son all testified when they sued that they were not informed that this procedure was going to be taken place. His doctors contradicted this. No, we told the plaintiff about this procedure. But then they admitted that they didn't really talk about the details of the procedure itself or the possible dangers. And so this California appellate level court says, look, a physician violates his duty to his patient and subjects himself to liability if you withhold any facts which are necessary for an intelligent consent to the proposed treatment. And that each patient presents a separate problem. You can't treat all patients the same, right? This is what makes consent really challenging and really difficult, right? Because there's a certain amount of discretion that a healthcare provider might have to employ to ensure that there's a full disclosure of facts to this particular patient. It might be slightly different with another patient, but all of this is necessary for that informed consent. So this is what we get, that informed consent by 1957. There are two sort of similar cases from 1972 that also talk about consent. One, Canterbury v. Spence, dealt with a young man who worked for the FBI, sort of just starting out on his life, right, and his career. And he had been suffering from a lot of back pain. And so his doctor suggested he undergo a laminectomy to see if that would, maybe there's a pinched nerve, see if that would remove some of his pain. Now, after surgery, he's in the hospital. After surgery, I don't know if it was the next day or so, he gets up out of his bed to go use the restroom and he falls. Right? Basically, what he finds out is that his legs are partially paralyzed. Are they paralyzed from the procedure? Are they paralyzed from the fall? That's sort of an issue that's up for debate at this stage of the case. But he really lived, so he was partially paralyzed in his legs and permanently incontinent for the rest of his life, spending most of his life on crutches, then in a wheelchair, and then finally, toward the end of his life, he was confined to bed. So he sued, but he lost his case twice. And we can talk about that maybe in a little bit as to why he lost his case. Over on the other side of the country, back in California, a man by the name of Ralph Cobbs was suffering from a duodenal ulcer. And so his physician suggested a procedure. Now, this particular procedure for dealing with this type of ulcer has a 5% risk of injury to the spleen. So for Cobbs, he was in that 5%. His spleen gets injured, so he goes through a second surgery to have his spleen removed. Something wrong goes there. He has to have a third surgery that partially removes his stomach. And so he sues. And the court, the California Supreme Court in 72, says, look, although Dr. Grant explained the nature of the operation, he did not discuss any of the inherent risks of the surgery. So what we get in all of these mid-20th century cases, although we had aspects of it, I think, in the older ones too, is that engaging in that informed consent duty is really, really challenging. Because on the one hand, it's the patient who has to be able to understand, what are the options available? What are the risks and dangers inherent or potentially inherent in each? How do I make the choices to what type of medical treatment I want to undergo? Because true consent to what happens to oneself is that informed exercise of a choice. But the problem is, even the most intelligent and educated patient, may not be so educated when it comes to medical procedures, right? And so the challenge is that because the average patient has little or no understanding of the medical arts, oftentimes we only have our healthcare providers to rely on. So there's a therapeutic privilege, right? That a physician should know what the patient's informational needs are and be able to frame the information, especially that medical jargon, that medical information, in a way that encourages our understanding. Now, the California Supreme Court went even further, which really made physicians and malpractice insurance companies very, very anxious because they said, look, it's not about a reasonable doctor standard, not what a reasonable doctor, what kind of information a reasonable doctor would divulge to a patient in a particular, with a particular procedure. It's really about a reasonable patient, right? Our healthcare providers should weigh the risks of all of our medical options against our individual fears and hopes, meaning that they need to know something about us in order to discharge their duty appropriately. And the California Supreme Court said, look, this evaluation and the decision of what kind of procedures we're going to undergo is a non-medical judgment that's reserved to the patient alone. All right, I've been mostly talking about consent in medical treatment context, but we also, right around this same period, mid-20th century, also get changes in the ideas of consent in medical research or being a participant in any kind of research. We, of course, could look at the Nuremberg trials and the Nuremberg Code that comes out of those trials post-World War II. If we're going to be a participant in research, we must voluntarily consent, right? The experiment should yield fruitful results for the good of society. The experiment should avoid all unnecessary physical and mental harm. And we as subjects should be at liberty to bring the experiment to an end any point in time that we want to. Right? We also see right around this time period, the US Public Health Services studies, the Tuskegee syphilis study here in this country that went on for 4 decades, also studies that we're finding about now in the last couple of decades that happened in Guatemala. In post-World War II area, the consent abuse is there. And the revelation, the expose about Tuskegee in the press in 1972 leads to the National Research Act in 1974, which eventually leads to a document that is just essential in medical research, the Belmont Report by the end of the 1970s, talking about what kind of protections should human subjects of research have. Things like autonomy, beneficence, justice. And maybe I'll circle back around to the Belmont Report. But it wasn't just these egregious cases, these egregious abuses of consent in medical research that you get from Tuskegee or from Nazi Germany. Right? We also find that there were consent problems in routine medical research. And if we look at, in particular at the post-World War II era, 1945 to 1965, which sometimes has been called sort of the golden era of this type of research, you had this influx of federal dollars in research, a 600-fold increase in federal dollars after World War II. And in the midst of all of this, an anesthesiologist from Harvard, Henry Beecher, started to say, you know what, when I look at all of these routine clinical trials, there's a lot of research abuse going on, lack of consent, high ratio of risk of treatments, or subjects having known treatments withheld, or vulnerable, unaware subjects, children who are institutionalized, prisoners, you name it. And he actually wrote an expose in 1966, highlighting the fact that these are happening in routine medical research and we need to do better, right? We need to do better. Across the pond, Maurice Papworth also was doing something similar. And one of his main books at the time was Human Guinea Pigs. So mid-20th century, we're really starting to think about consent, protecting people's decision-making authority, protecting their control over their bodies, both in a medical care context and medical research context. But here's one of the main questions: is consent absolute, right? Consent is never, any right we have is never absolute. And I'm going to speed up a little bit because I know I'm going, I think I'm a little bit behind here. Our rights are never absolute. There are always exceptions, and there are exceptions to consent. One of the areas I want to focus on is contagious disease, but we have other issues as well. There's sometimes involuntary hospitalization or commitment, court orders. We talked about civil law discovery, statutory reporting, duty to warn. I said to warn third parties, not to warn them. But let's talk about contagious disease, because here we are in the middle of a pandemic. And one of the questions is right now, can your employer, can the state mandate that you get the COVID-19 vaccine? If we go back to a Supreme Court case from 1905, this is still precedent, although it has been modified in the last 115 years, Jacobson versus Massachusetts, where there had been a smallpox epidemic occurring in the Northeast, not unheard of. There had been smallpox epidemics, in the 1700s and the 1800s, even right around this time. On the books in Massachusetts was a statute that basically granted city boards the authority to require vaccination when necessary. There were some stipulations. Vaccines had to be free. There had to be an exception for children not physically fit, and you would be fined as an adult if you didn't comply. So in 1902, the Cambridge Board of Health issued a smallpox vaccination mandate, basically because, look, we've got smallpox going on in our city and we need the speedy extermination of the disease. There had been at this time a modest anti-vaccination movement happening in the United States, although it was not well connected and not very strong. It was far stronger and far more coordinated over in England, but there was some anti-vaccine movement even happening at this time. One of the dissenters to this mandate was Reverend Henning Jacobson. He was not an anti-vaxxer, right? But he and several others refused. They were fined for not complying. And eventually, Jacobson appeals his case all the way to the US Supreme Court. He's the only one that goes all the way to the US Supreme Court. But at every level of the courts in Massachusetts, they lose their case. Jacobson takes his case to our highest court, in part because he wants to have the court look at his 14 points against compulsory vaccination. Now, a few of these points against compulsory vaccination were his sincere personal reasons. And that's really what he had problems with the smallpox vaccination as a child. He didn't want to go through it again. And that's really what he was fighting here. But in order to fight any kind of legal suit, you need money. And he did receive some financial support from an anti-vaccination group. And so the rest of his 14 points pretty much read like an anti-vaccine pamphlet. 11 of them were about the alleged injurious or dangerous effects of vaccination, and one was about what vaccination consists of. And he basically claimed, look, his 14th Amendment due process rights, the mandate invaded his liberty and bodily integrity, and the law was unreasonable, arbitrary, and oppressive, and an assault upon his person. You might have recognized some of these concepts or statements being tossed around today. But the Supreme Court disagrees with Jacobson and says, look, the liberty secured by our Constitution isn't absolute. Real liberty could not exist if everyone just got to do what they wanted to do, regardless of injury that may be done to others. And that within our law, we are under all kinds of restraints and burdens in order to secure the general comfort, health, and prosperity of the state. So liberty is not absolute. The legislature, according to the Supreme Court and the Board of Health, had the right to determine how to control the smallpox epidemic, primarily through their police powers, an older idea that we get from John Marshall. But here's what I like to emphasize with Jacobson, and I could do an entire hour just on Jacobson. This was a very, very narrow decision, looking at the type of disease that was involved, the state of smallpox vaccination science, which was pretty darn good, even in the early 1900s. And also the court emphasizes multiple times that this precedent should not be used to justify any other case that's arbitrary or oppressive. It's a very narrow decision. And they said, look, some egregious examples could be suggested, and they were kind of prescient about that. Where is Jacobson now? We have two cases in relation to our pandemic that have cited Jacobson. One from Maine about Maine's 14-day quarantine, and which invaded our right to our freedom to travel, which is a very serious matter. And I will agree with Judge Walker on that. It's a very serious matter. Judge Walker was appointed by Trump, and he claimed, even though the plaintiffs lost their case for legal reasons, he claimed that Jacobson is way too differential to states' police powers, and that the permissive Jacobson rule floats about in the air as a rubber stamp. On the other hand, we get a case out of a district court in New York from a judge that was appointed by President Obama. Similar type of case. And Judge D'Agostino says, look, Jacobson is settled law, even if it's not absolute. This century-old principle has been repeatedly reaffirmed this past year by a host of judicial voices. But of course, these are district-level courts. This is not a Supreme Court. But we've had some, so where does Jacobson stand in relation to the COVID-19 vaccines? Some people are still debating this, even though it is still precedent, but it has been modified over the years. All right, for time reason, I'm going to skip over one of my favorite areas, which is our rights in our tissues that have been removed from us. And these are great cases, but I don't think we have time. So we can come back to that in relation to questions if you like. Let me wrap up on what exactly is informed consent. And I'm going to focus again on medical care rather than experimentation. Right? A physician, healthcare provider must explain the nature of our medical condition, the nature and purpose of the proposed treatment, as well as a discussion of what might succeed, right? Likelihood of success, both risks and consequences. Risks are things that could happen. Consequences are things that will happen. I tell my students, think of these oftentimes like in post-op orders. You won't be able to lift anything heavier than 5 pounds for 3 months. You're going to have to irrigate your wound 3 times a week. Those are consequences, things that will happen. As well as alternatives. What are all of the other types of treatments I could undergo? What are their risks and consequences? As also, what about if I just choose to do nothing? Here's what I like to emphasize. Consent is about communication. Informed consent is not the written or signed document, right? It's the discussion and conversation between the healthcare providers and the patient or the patient's representatives. The only thing the consent form is evidence that the consent process has happened, right? That consent form serves primarily institutional and legal means, not necessarily patient needs. But consent in practice is really, really difficult for so many reasons, right? One, we don't necessarily like outside entities intervening in the doctor-patient relationship for a whole host of reasons. All these strangers at the bedside, to use David Rothman's term, make the exam room really crowded and can sometimes interfere with the doctor-patient relationship. Consent is challenging. I think I've sort of emphasized that in a few other places. I love looking at House MD, where one of the doctors in this medical TV drama is trying to explain this very complex procedure to the parents of this boy who needs treatment. And he uses all this medical jargon. And he finally says, look, I'm sorry, I can explain this as best as I can, but the notion that you're going to fully understand your son's treatment and make it an informed decision is, well, it's kind of insane. Here's what you need to know. It's dangerous. It could kill him. You should do it. So sometimes these consent conversations are strategic, right? I don't think they should be strategic, but that's how we sort of engage in it in practice. You'll hear language like, did you get the patient's consent? Or go consent the patient, or mistaking that signed form, as in that case from 2019 we talked about at the top of the hour, as consent. Healthcare providers, this has been studied for many, many decades, are hesitant about aspects of the informed consent process. They lack time to engage in it properly. Oftentimes they lack training and comfort. A lot of times, especially younger healthcare providers, don't like to talk about the risk of death because they're just not comfortable with it. And there have been studies that have shown that particularly younger healthcare providers earlier in their career don't really know all the risks and alternatives. And so they really truly can't engage in a true consent conversation. On the flip side, some patients don't want to engage in the process, or probably more to the point, don't know how. So we can't just look at training healthcare providers. I think we also have to train patients as to what informed consent is. And legally, if you're going to sue for lack of informed consent, this is a sort of an add-on. Lack of informed consent is often not a suit of its own. You have to be suing for other tort issues, because you have to prove in a tort case both injury and causation. And it's hard to do that. Like say, well, one of the cases I didn't talk about, we'll go back to Canterbury actually. You have to prove that you wouldn't have undergone this particular procedure if you had known all of the details. And this particular patient, he went through another laminectomy. And so that really sort of sunk his legal suits. All right, I will leave you with a couple of slides. This is from another piece of work that I've been engaged with. I really think we have to move from consent to consensus. And primarily, I've been looking at Jürgen Habermas's theory of communicative action, which came out in the 1980s. Habermas talks about different ways of discourse and conversation. On the one hand, there's strategic action, where the aim of a speech act is goal-oriented. So for example, if I tell my students, wear a mask when you walk into the classroom, or maybe you own a business and you have a sign on the door that says, put on a mask before you enter, or don't wear a mask. The goal of that type of communication is just getting the outcome desired, right? You don't really care if your business goers understand why you want them to wear a mask. You just want them to do it, right? Maybe you have valid reasons for it, but you're not engaging in that conversation under strategic action. As opposed to communicative action, Habermas says this is where the participants, what they're seeking is not just reaching a goal, but shared understanding, that they're in an interpersonal relationship and they're going to come to an understanding about a particular situation. They might not necessarily agree about the situation even at the end, but at least they understand it. And they do this through dialogue and debate and the expression of what Habermas calls criticizable validity claims, right? If I say to my students, you must wear a mask, and my student says to me, well, masks are ineffective, I might say back to them, okay, well, tell me, why do you think they're ineffective? And they'll say, well, why do you think they are? And we start to engage in dialogue and debate using evidence, criticizable validity claims, so that hopefully by the end of it all, if we respect each other as equal and valuable contributors, and engage in this conversation with a sense of sportsmanship, that's my colleague Jack Simmons' term in relation to Habermas, that by the end of it all, maybe we will both come to accept an outcome based on the unforced force of the better argument. It's not just that my way wins, according to Habermas, it's that the better argument, we come to understand the better argument. And I really do think that that's what informed consent is about and in what it needs to be. I'm going to leave you with one last example. This is from Thomas Beecham and James Childress's Principles of Biomedical Ethics. They have basically written what we would call the Bible of medical ethics. This was back in the late 70s. Beecham was he was basically the author of the Belmont Report too. He was working on this simultaneously. what we see from legal cases and medical ethics, that our choices as patients may be valid even if we choose something that a reasonable person would do something differently, right? Our choices are still valid even if they're not reasonable. But Beecham and Childress says, well, but what happens when a patient's beliefs are demonstrably false or ignorance prevents an informed choice? And here's what they say, that it may be permissible or even obligatory to promote autonomy by attempting to impose unwelcome information and pressure patients or subjects to change their beliefs or to process information differently. That actually might be part of the informed consent process, even though it seems like it's encroaching upon autonomy and free choice, but it's trying to facilitate that autonomy. A somewhat problematic example that Beecham and Childress give in this book, and this, of course, is an example probably from the mid-20th century, about a 60-year-old woman from Appalachia who is in a hospital being treated for a broken hip. During the treatment, her doctors discovered she also had cervical cancer, and a hysterectomy would actually cure this, right? But they can't get her to consent to the procedure. She has limited formal education. She believed that, well, people with cancer are sickly, and I feel fine. And then, of course, we have elements of racism here. She distrusted her attending physician because that physician was African American. So no information that they provided, including a biopsy, would sway her. And so the woman's refusal was not informed, stemmed from a lack of understanding, and again, those racist elements. And here's what Beecham and Childress say. And again, we're going back to the mid-20th century, that only through intense discussions with a white physician and her daughter eventually corrected her belief and led her to consent and saved her life. Today, healthcare institutions also would want to protect their healthcare providers against abusive and biased racist patients. So put a little caveat there. Here's what I say. Compared with that Pratt case with Mrs. Davis from a century ago, here, Beecham and Childress are showing that sort of a communicative approach addressed the patient's life world with the aim of shared understanding, though not necessarily in agreement with all of her views, and reaching a consensus about the hysterectomy-based treatment that was, in this case, unlike in the Davis case, efficacious rather than harmful. I will leave you with this. I think we need to move on from did you get the patient's consent to did you reach consensus with the patient, and respect for bodies within our practice and our policies and our law, and the recognition that our bodies overlap. Our bodies are not necessarily, we're not necessarily islands unto ourselves. I think I went a little bit longer than I was supposed to. So I'm going to leave you with that. And I really want to thank you for your time. And I hope I didn't go too fast.
I want to thank you, Leigh, so much. And I would like to open it up for questions, but unfortunately, we only have time for one question. So we'll take one. And I'm sure Leigh will be back again for Food for Thought, and we'll be able to ask her more questions.
With a more concise topic.
I have one. I don't want
Go ahead, Carol. We'll take your question.
In a couple of, especially the earlier ones, like Moore versus Williams, nowadays we have Good Samaritan laws to protect somebody from providing care and service, and they won't be charged with any type of offense against the person that they're trying to save, especially if it doesn't go well. But in that particular case, the physician, although he wasn't a good Samaritan, he was working as a physician. If he saw danger and harm while he had on the table, does he not have an obligation to fix that? I mean, at that point she was sedated, and surgery wasn't as advanced as it is now. So maybe the idea of closing her up, asking her consent, then opening her up and doing it again would never have been an option back then. So I'm going to be quiet now, but that general idea is difficult for me to understand.
Right. Carol, they're really good questions, and I'll take each piece of it. So when it comes to you're right, we do have Good Samaritan laws, even though that wasn't necessarily involved in this case. And oftentimes most of our Good Samaritan laws will say, look, as long as that provider doesn't engage in gross negligence, they're protected in those situations where Good Samaritan laws apply. There's some really great cases about doctors who are on airline flights and called for assistance, that we can do that maybe in another day. You're right. So with the Moore case, or even like with the Schlowendorf case, even today, if I am under anesthesia in the OR and my doctors open me up and go, oh, wait a minute, what we thought what she consented to isn't the right procedure. We really need to do a different procedure instead. Oftentimes the general rule of practice in healthcare, even today, is if it is not life-threatening, you basically close up the patient, you get them out of anesthesia, you wait until they're able to consent again, and then have them consent to the new procedure. When it comes to Mrs. Schlowendorf, and you have to know the real details of the Schlowendorf case, where it was a hysterectomy for fibroids, not, when you read the case, it sounds like it's a cancerous tumor. I always talk with my patients about, most of us, many of us might say, look, man, you already have, especially then, you already have me under ether and opened up. I don't want to go through a second operation. You find something, you take it out. Schlowendorf, she said, no, don't remove anything. And so in her situation, they should have just closed her back up and talked with her again, same within the Moore case. Yeah. So as long as it's not life-threatening, and the physicians can get consent at a later stage to do another operation, that's usually the way it's supposed to go.
Thank you, Leigh. Unfortunately, as I said, we're not able to take any more questions, but we will have you coming back to our Food for Thought. And also, I would like to invite everybody for next week's Food for Thought program at the same link and the same time. We'll be hosting the Galil Culinary Institute by Jewish National Fund. So thank you, Leigh, for being with us today. It was so interesting. And thank you, everybody, that joined us.
And please feel free to send me questions. I didn't mean to go so long. Thank you so much, Sunny.
Bye.